A declaration is hereby made that the entire unconstitutional change process promoted by the Steering Committee on the Implementation of the Building Bridges to a United Kenya Task Force report is unconstitutional, null and void.
This was a very deliberate design to plunge the country into a constitutional crisis and chaos through judicial activism.
Na tutafuata sheria kuenda hiyo appeal. Lakini tunaona hiyo judgment kama iko na motivation nyingine beyond the law.
And we are urging the President and his administration to internalize this judgment, because so far all we are getting are knee-jerk reactions. To internalize this judgment and see that it is good for the country.
Indeed, that judgment from the High Court was as damning as it was numbing. On its wake, confusion in the handshake ranks with BBI principals, President Uhuru Kenyatta and former Prime Minister Raila Odinga quietly mulling their options as their lieutenants, both legal and political, examine the black box for any clues. Talk of the Court of Appeal and even the Supreme Court is now gathering momentum. But will the courts save BBI from the courts? Joining me now for that discussion is Paul Mwangi, former BBI Joint Secretary, and of course he represented some of the respondents in the case, together with Nelson Harvey, President of the Law Society of Kenya, one of the lawyers who led the petition against the BBI. And we want to get into that discussion right now. Before, however, gentlemen, and welcome to the studio. Before we get into that substantive discussion on the judgment, I want us to talk a little bit about the intensity of those personalized attacks we've seen against the judges in the wake of that judgment. And I want to start with a quote from an interview yesterday where Raphael Tuju, Jubilee Secretary General, said these words, and we can put that up on the screen. Judges should learn the word interdependence, because as soon as they finish a ruling, they need policemen to escort them home. Nelson Harvey, let me start with you. Is that a threat to the 5 judges?
First and foremost, may I stand behind the Kenya Magistrate and Judges Association, together with the judiciary, in my capacity as the Chief Servant of the Law Society of Kenya, to condemn in the strongest terms possible pronouncements that appear to be coming from individuals who hold high offices in the Jubilee administration. Amongst these is Raphael Tuju. I do not want to prefix his name with the title Honorable, and also the gentleman by the name Peter Munya, who unfortunately happens to be a lawyer. The independence of the judiciary is something that is not negotiable. Judges ordinarily are mined from the legal fraternity and volunteer to serve in an arm of government. Their security is due to them as a matter of right, not a privilege. And anyone who feels aggrieved by a decision of the court is entitled to disagree with that decision, but not to degenerate to the level that we have experienced lately. Look, for instance, what Raphael Tuju said yesterday reminds us of what happened in Uganda in the 1970s, where if you ruled against President Amini, then you suffered the risk of being killed. And many people, many judges were indeed killed. This is exactly what Raphael Tuju is telling us. But you see, for Raphael Tuju...
Well, he did not exactly use those words. That's your opinion on the program this evening.
Well, Wahiga, at my age and stage in life, I'm able to see beyond the words. It is not in the realm of conjecture that about 4 years ago, there was an attempt on a senior judge in this country. Now, let me go back to Raphael Tuju as an individual. Not so long ago, he lost a claim before the High Court. And what did he do? He started castigating that judge, making a spurious application to disqualify the judge on grounds that were not merited. Who is Tuju? He's a cabinet secretary.
Yes.
And he holds an office that does not permit him to degenerate to this level.
Okay, and I was going to ask you not to get too deep into other matters. He's not here to defend himself. But Paul, you come in and you have raised concerns about judicial activism and a cancel culture within the judiciary. But surely statements like those, do they worry you?
What Kenya is going through what I would call the third conversation on judicial independence. And I'll say this as somebody who, throughout my legal career, what I've commented throughout on the going-ons of the legal profession and particularly the politics behind it. The first conversation of judicial independence happened in the 80s and early 90s, and the conversation then was whether the judiciary was independent of the executive. And at that time, we had contract judges who were coming from the UK and who were being used by the state. That conversation ended when we went into multi-party, because after that, the executive lost a lot of its power over the judiciary, and we started getting local judges. Then it started the second conversation. And at the time of the first conversation, the notable character then was Chief Justice Hancock's, who had a judge in the High Court who was called a gatekeeper, who we know as Dr. Dugdale. The second conversation started about corruption, and it came in with Goldenberg. The Chief Justice then was Chief Justice Tesoni, and I will not mention the other judges because some are still there. And the concern then was that Goldenberg infiltrated the judiciary, and the entire judiciary became corrupt. That was resolved through the series of radical surgeries that went through. And the radical surgeries were not about state interference. Radical surgeries were about corruption. And that conversation is really not over, because both Justice Maraga and Justice Mutunga have alluded to the fact that they were also dealing with corruption among the ranks of the judiciary. But a lot of it was sorted out with the vetting board of judges and magistrates.
And I apologize for interrupting you, and thank you for that history, but then bringing us to where
now,
we are
the
right
third
now.
conversation is now what is taking place, and that is what has been blown open by the BBI case. The third conversation is about the limits of judicial power in respect of the other arms of government, and the question of whether the judiciary has become captive by activists, by human rights activists, who have an agenda in which they're using the judiciary to fulfill. But as we go along, I will tell you where I come from in that, and I have the evidence to show that that is happening.
Is that a concern you'd have had if that 5-judge bench ruled differently last week? Is it a case of sour grapes, Paul Mwangi, this evening?
I have written about it. I wrote about it very extensively last year. I have written about it all along. So it has nothing to do with the BBI case. It's only that the BBI case has actually blown this conversation into the open. And that is a conversation that is now going on.
Did you at any point in December 2020 then consider appealing the constitution of that 5-judge bench by former Chief Justice Maraga? Why now?
No, I'm not questioning the constitution of the bench. They have made the ruling, and we are appealing against it. And I'm not touching the issue of how it was composed. I am saying, I'm first getting away from BBI to tell you that these conversations are taking place within a context. And that is where you're beginning to see some things being said, which a lot of it has actually nothing to do with the BBI case. There is a conversation that has come alive, brought alive by what happened at the BBI.
You say you have proof of something. When might Kenyans...
You know, the question of... the third conversation was actually blown open by Chief Justice Mutunga. And that was the first human rights activist who came to head the judiciary. And there are people who suspect that he did, and I don't want to go into that, that is something I would have to write about so that I can put my evidence, that he did collect right-thinking judges who thought like him in the pursuit of this activist agenda. In the same way Hancock's had Dugdale, in the same way Tesoni had his group, so did Maraga. And that's when Justice Mutunga left, in August, I think it was August 13th, 2019, he launched, he was seen at a ceremony of a group called the Defenders Coalition. The Defenders Coalition is a group of human rights activists who believe that you must stop being neutral. And I'm saying they have a website. Defenders Coalition.
That's what, if I Google that now,
you need to cease to be neutral, and in the words of Justice Mutunga, you must wrestle power away from politicians. And that's on record. The concern now is whether that movement has infiltrated our judiciary. Because that would mean that then there are judges who are pursuing the agenda of the Defenders Coalition. And that is disturbing.
And that is what is concerning you this evening?
That concerns me.
Mr. President, is that new to you? And how bad is a activist judiciary, activism judiciary for Kenya at a time like this, if what Paul Mwangi and others of like mind feel is the truth?
The last genuine book that was written by my very good friend and senior was called The Black Bar. Thereafter, he's just been writing fiction. Every day he writes fiction.
Every day he's writing fiction?
Fiction. So
allegations of infiltration of the judiciary by activist forces.
Wahiga, in 2017, we were arguing the petitions before the Supreme Court with my friend here. Why didn't he raise those concerns? Most of the labeling decisions prior to the major decision in 2017 were argued before these judges, and decisions were made in favor of a political party in respect of which he is the chief legal advisor to the patron. Do the judges become activists only when they make a decision perceived to be against their cause? I do not think that is the proper course to pursue. But as he has said, they are already appealing against the matter. For that reason, therefore, I do not think it is an opportune moment for him to conceptualize that theory of the defenders of justice. I think it's one of his fictional writings.
I think, Maura, the question would be, does the defenders' coalition exist? Yes, it does. Is the defenders' coalition aimed at grabbing power by activists from politicians? Yes, it's their stated fact in the website.
I would be surprised to find a website that says
yes,
our
it is there. And you look for also the speech that Justice Mutunga gave on 13th August 2019 at Serena Hotel, because that's what he called them out to do. Then the question is this defenders' coalition headed by the former Chief Justice of Kenya? Yes, it is. Now, the concern is, did he start this when he was Chief Justice, or did he start this after he left? Because then we have to start looking at pronouncements that are made and ask whether they are made independently in pursuit of judicial power, or whether they are influenced by groups such as the Defenders Coalition.
I've actually pulled up the website of that group, and I don't want to get too much into it, but I don't see what you're talking about. I see championing safety, security, well-being of human rights defenders.
I think
I told you it's fictional.
Get to the speech that was given by Justice Mutunga, and I can't give that to you.
Maybe that's what we'll
13th August 2019, Serena Hotel.
13th August 2019, Serena,
yes,
Hotel.
Serena Hotel.
Okay, we'll pull that up.
It was one of the mainstream medias carried it, at the top and the banner of the article is "Wrestle power from politicians." That's the banner of the article.
And take it where?
Well, the question they were saying is that human rights athletes need to go into politics and take power and lead themselves. That he stated.
Okay. Gentlemen, I don't know if the President there has anything to say on that. We can get back to this a bit later on. But you know, I called you to talk about that judgment.
I said we must now have the discussion in the light of the fact
of what you said in the opening.
Yes, because even in a lot of these are the things that are not being said. These are the concerns that are not being raised. But they're in the background, and they're coloring everything. Every appreciation of what the court did is being discussed in the light of that concern. All I am doing it is I am laying out into the open and saying, this is the real conversation taking place. And
Paul, as a senior advocate, don't you see what words like yours on a show like ours tonight could do for the reputation of the judiciary? Does that warn you, does that concern you, that you will be before that judiciary tomorrow and in the days to come?
You know, when I
make a statement like that, many Kenyans take it as gospel truth.
When I wrote a book and talked about how corrupt the judiciary was, we got problems, and we were told we were doing the same thing, that we were ruining the judiciary. It took the radical surgery for people to actually see that what we had been saying all along was true. I remember the only other person who was commenting about it then was Ahmed Nasser, who was the only other person who was writing and commenting about the corruption that was going on. And when the radical surgery came in is when the truth came out. So sometimes if we don't have these conversations, then things fester. And it is important that we start having this conversation, because judicial independence cannot always just be about the executive. Judiciary must be independent from everything. Okay. And if there is a possibility that they are falling under other third-party influences, that needs to be discussed.
Nelson, you still say it's fiction?
Well, I can even see you are transfixed with the pronouncement emanating from his mouth. But anyway,
I'm a good listener. That's why I have this job.
Perhaps what my very good friend and senior should do is to originate a petition before the Judicial Service Commission, present this evidence, and if it meets the threshold, then the judges will be removed. And I, for once, have undertaken a similar exercise. And if at all there is evidence to sustain the spurious allegations he's making, I'll be the first one to support them. But perhaps we close that thematic area and address issues that are not really of a fictional nature.
And you've thrown a challenge to Paul. Paul, is that something you would do? Move to the JSC with? I mean, those are
my work as a writer is to take it, to bring it into the open. That's what I did with corruption in the legal profession. That's what I did with corruption in the judiciary. And I published an article last week, and I said that this BBI case is not about law. It's about politics. And my work is to prove that this is about politics, not about law.
Let's get straight into that BBI judgment then, gentlemen. I think now is a good place to start. Let's put up a little bit of what was said last week in terms of declarations at the tail end of that lengthy judgment. Constitutional process, if we can have that up on the screen. This is what that 5-judge bench declared, that the basic structure doctrine is applicable in Kenya, and that the basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. And basic structure doctrine, which basically means that certain parts of the supreme law cannot be erased by its legislature, and that is now applicable in Kenya. We'll talk about this next one after that. Let's focus on basic structure doctrine briefly. Nelson, I want to start with you on this one. The High Court found that this is applicable in Kenya at this time. But for the clarity of Kenyans tonight, what did you make of which parts of the Constitution cannot be amended and which parts can? Because legal experts out there say that the 5-judge bench did not really come out clearly on which ones can and which ones can't be amended.
Well, what the court did was to chronicle the constitutional making process that culminated in the promulgation of the current constitution on the 27th of August 2010. And they punctuated the process with hallmarks. For instance, we start with 1963. We're given the Independence Constitution. By 1969, the Independence Constitution has completely been overhauled by amendments which writers of law have said were unconstitutional because they tended to change the entire framework of the Constitution, a process that can only be undertaken by repealing a constitution and not by amending it. Now, come 1997, an elaborate legal framework was put in place to ensure that we progress towards the quest for constitutional reform. The next punctuation point was in 2004 when we had the Njoya case. And in the Njoya case, the court said there are certain processes that must be implied in the making of the Constitution and the Constitution itself. For instance, the basic structure as we know it in the current Constitution is this. We have a presidential system of government. You can differentiate this from a parliamentary system. We have a cabinet that is not domiciled in the National Assembly. We have a judiciary that is independent and is not an arm of government. These are the key features of the structure of the Kenyan Constitution. Now, if you look at the BBI bill, what did it intend to do? It intended to have a hybrid system in which we have a president, we have a prime minister, and 2 deputy prime minister. Over and above that, the entire cabinet or part of it could be appointed from the National Assembly. And then within the National Assembly, we have a leader of the majority. And then outside that, you come to the judiciary, and they were to install a prefect of sorts called the ombudsman. And then over and above that, there was an intention to create 70 constituencies. Now, the manner in which Kenyans agreed to formulate the arrangement between themselves as the people and the ruler, culminating into the Constitution, did not conceive of a situation whereby the ruler will take it upon himself or herself to alter this structure. You see, effective the 27th of August 2010, we had the Second Republic. Now, by the time we are having the Second Republic, there have been a raft of almost 37 constitutional amendments undertaken throughout the period from 1963 to 1991, when Section 2A of the rested Constitution was removed. Then, if you were to change that basic structure that we created on the 27th of August, you must create a new republic. You must go back to the people. You can't do it in the manner in which they're doing it.
Specific, so which chapters of the Constitution, in your view, then, are the ones that cannot be? Are you talking about what, chapter 1, chapter 2, 9, 10? That's the answer I'm looking for from you.
We're starting with chapter 1, on the republic, the nature of the republic itself. And then we go to the chapter on the executive. Then you go to the chapter on the legislature. Then you go to the chapter on the judiciary. And then there is a chapter on independent commissions. And what is fundamental here is the IEBC itself. Because it's only the IEBC that has been given the power to alter, increase or expand the number of constituencies from 290. And there are elaborate parameters through which this can be done. And the biggest flaw that was pointed out by the court was this, and indeed this was our complaint before the court, that what the BBI bill has sought to do is to create 70 constituencies, apportion them without following the procedure given by the Constitution. And then the court said the manner in which you are to apportion, name, and allocate these constituencies is one of the eternity clauses. It cannot be changed.
Let me see if Paul Mwangi left that, left after he listened to all that. Did he have the same clarity as Nelson had?
There was no clarity, and it has brought us into a big crisis. Because first, the court said that the structure, basic structure is, they said it's in the preamble, in the 18 chapters, and in the schedule. That describes the entire Constitution. So then the question arose, and then they said it's not everything in those chapters that is basic structure. So then the question came, then what are those provisions that are basic structure? In the words of the court, page 179 of the judgment, it said that it is not possible in that case to give an exhaustive list of what is basic structure, and said that we would have to go and look at the history and study and go through a very long process to agree on what that basic structure is. So by the time even the court is pronouncing itself and telling BBI that you've gone against basic structure, it itself is unable to say what that basic structure is. Now, the problem starts that it is now left to judges to be telling us what that basic structure is. One of the things we saw with the BBI case is that judges can differ very, very widely as to the interpretation of law. We already had the judges reading from the same law about the quorum of IEBC and reaching two totally different decisions. So you're talking about 150 judges in the High Court, 30 judges in the Court of Appeal, 7 judges in the Supreme Court, possible 187 different opinions as to what can be our basic structure, because one judge might differ from the next. So how do you have a constitution that is capable of all these interpretations? It would mean then that the judges would have to sit down and agree, because we must have a constitution where you know where you stand at every one time. What the judges are saying is that at the moment, we all don't know where we stand. You will know whether something is basic structure the moment you touch it. And it might depend on which judge you go before.
I'm listening to the both of you, and I'm wondering if you looked at the same document. He speaks with clarity on basic structure. It's very clear to him what the judges were talking about. You say greater confusion emerged.
Yes, because, and I'm using their own words.
Who should Kenyans listen to this evening?
In their own words, they say a list of what is basic structure is not possible at that time. They said that. Which means, as we stand today, you would have to go before the High Court on a particular issue for them to tell you whether it's basic structure or not. So our constitution is now, as we stand, totally indeterminate until you go before the judges. So unless, and even then, you have a whole litigation process where one judge of the High Court can think this, the other one can think this. You can't have a constitution operating that way. Unless they all sit now and agree what is basic structure and tell us. Then if they did that, whose constitution have this become? It becomes the constitution of the judges, not of the people.
Mr. President, you can respond to that, even as you tell us, is there anything you disagree with about the judgment that you listened to last week? Anything at all?
No, I agree with the judgment entirely.
Every page, every sentence.
Every page, I agree with it. We formulated a case before the court, on my part acting for the 4 petitioners led by Dr. David D. There were many other petitioners. Now, it is quite evident that my learned colleague Paul Mwangi must have attempted to answer his own question before the court. But the clarity of thought in our mind is manifest in the manner in which the court has determined this issue. And these attempts to throw here and there erroneous conclusions about what the judges made, it's not sustainable. Let me just pick one for you. Under Article 88, the IBC is constituted. And under Article 250, all the commissions are set up with a minimum of 3 commissioners and a maximum of 10 commissioners. Now, I mean, for those of us who have some basic knowledge in physics and chemistry as well as mathematics, you have what we call optimum capacity of performance. So the optimum capacity of performance of a commission is supposed to be 9. Now, when the commission is at the verge of almost dying, it is at the minimum capacity, 3. But that article of the Constitution itself has said the IBC will perform functions in a manner set out in national legislation. Then we have the IBC Act, which has expressly stated that the quorum for the IBC commissioners shall be 5. Why the lack of clarity here, unless your vision is obscured? It is as clear as daylight.
For those who say that the Supreme Law talks about 3, and that's how they see it?
No, you see, the Constitution is supposed to be this framework. It cannot provide with specificity and detail for everything. It gives the guiding principles. And the guiding principle is the minimum and the maximum. But it says expressly, there shall be an act of parliament that shall detail the manner in which IBC shall function. And in previous decision, the question that was before the court was not a question of quorum. It was a question of constitution. So IBC may be properly constituted with the minimum. But what is the quorum? Where do you find the quorum? You find it in national legislation. And if you continue prevailing in the miasma of confusion that is created by my colleague here, you will never be able to perceive the issue with that clarity. And you will continue faulting the judges. That is not the case.
Okay. And maybe that's why it's good if, from your perspective, that's why you're here, in case you feel what Paul is saying doesn't make sense, you're here to also give your view on the same. And Paul, before I give you a chance, let's pull up the another declaration that came out from the judges, because I also want to talk a bit of politics with these 2 gentlemen a bit later on the program. They said that the president does not have any authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative or through a popular initiative under Article 257 of the Constitution. And Paul, even as you respond to what Nelson had to say, critics of the BBI actually say that it was an executive-sponsored amendment disguised as a popular initiative.
Okay, first, on the issue of IBC, the main question that needs to be asked is, in the process of trying to resolve this issue, did the court meet a situation in which a statute was in conflict with the Constitution? Because if the Constitution is saying you can be 3, and which means that so long as you are 3, whatever you do complies with the Constitution, and then you meet an act of Parliament that is insisting that you must be 5, and if you're not 5, you have contravened the Constitution. Section 2 of Article 2 of the Constitution is very clear. The Constitution must win in case of a conflict. So it was not open to the judge to make an act of Parliament win over the Constitution. That would be undermining the Constitution. In respect of the issue of the president initiating, first, I say that was a phantom issue. Because first, it's not even based on the Gazette notice that the court was relying on. Because the Gazette notice asks the steering committee to make proposals for the administrative, policies, statutory, and constitutional changes that could be up. There is nothing in that Gazette notice that tells them to initiate anything. And therefore, if it's not in the Gazette notice, it does not exist. And you cannot say that there are instructions that the president has given to the committee that are not in the Gazette. The instructions of the president to any institution that he has the power to instruct are done. In fact, even the Constitution requires that every pronouncement of the president must be in writing. And if it is not in writing, it does not exist. So if it was not in writing that the committee is supposed to go and initiate, then that does not exist. But it's still a phantom issue, because IEBC itself was telling the court that the people who are promoting this drive is Honorable Dennis Owero and Honorable Junet Mohammed. They gave the court a letter which they had written to all the speakers of the county assemblies, of the Senate, and of the National Assembly, pronouncing who the promoters are. It was not open to court to come and substitute the decision of IEBC as to who the promoter is, and insists, without any evidence, that a third party is the promoter. That's why I say it was a phantom issue. It's introduced just to give credence to the necessity to close down BBI.
Paul, and you've of course followed this quite closely. I mean, you are joint secretary of the BBI. So who, and this might sound like a nonsensical question, but there's somewhere where I'm getting at with this. Who initiated the BBI process?
No, talk about the popular initiative, because that is what was before the court. The issue of the task forces and the BBI task forces had been in court previously, was ruled on by Justin Bativo. And he said he did not see anything wrong with the president exercising his powers. And he gave a go-ahead. And he even refused to trash the report that had been, and he was being asked to trash that.
And so tonight you're telling Kenyans there were two processes running, one after the other.
The BBI process stopped at the proposals and the second report that was handed over. That's a report we went and handed over in Kisii, and then it was launched later. And nothing was gazetted after 30th of June 2020. That ended that exercise. Come December 2020, Dennis Owero and Junet Mohammed go and decide to start a popular initiative 6 months later, after the steering committee is dead, because the steering committee's mandate under the Gazette ended on 30th June 2020. So it's not even possible for the judges to be saying that the steering committee is promoting an amendment of the Constitution. The thing was dead. It didn't exist. It's not even possible that it could be doing what the judges were alleging that it was doing.
President Harvey, come in.
Sometimes you may go to school and find that the teacher is much younger than you. It is an opportune moment for me now to school my senior on this particular issue. Just for a minute, and then I proceed to speak to the audience. As early as 1974, prominent scholars of constitutional law, and in this case I'm talking about Professor Ben Nobweze, had stated that the moment the president has been elected in a presidential system, he ceases being we the people. He cannot use the same power as an individual. In a previous occasion, I've created that dichotomy thus. There is Serikal and there is Mwananchi. The moment you become Serikal, you cannot be Mwananchi at the same time. It is as clear as daylight. Now, what are the documents that sustained these two committees, the task force and the steering committee? They are legal notices. One made in March 2018, and another one made sometimes in October 2020. Who signs those Gazette notices is the head of public service. You may want to hide this thing. It's like hiding a pregnancy. It will come to light. And the problem that bedevils my friends right now is that they've been trying to hide the identity of this initiative for a long period of time. 9 months are over. They must give birth to that monster that they are carrying. And we have seen this monster is not an initiative of the people. And you may even go further if you want to examine the Constitution and look at the definitions. There are clear definitions: a state officer, a state agency, and a person. A state agency, a state officer can never be a person. Now, if you look at it from that background, Wahiga and the people of Kenya, you realize that the Constitution provided for two avenues of amending the Constitution, not dismembering the Constitution, not repealing the Constitution, amending the Constitution. A parliamentary initiative which is available to the president and anybody in public office. How does he utilize that? He can do it through the leader of the majority in the National Assembly or in the Senate. He can do it through the Attorney General. But a popular initiative, on the other hand, was left for the people. And it was for good reason, because it was intended to enable a comprehensive change in the Constitution if need be, and to create a bulwark against attempts by those who are already in office to disguise themselves as the people and create a change, a new republic, which is not permissible. Do
you buy the view that after the judgment last week, any attempt at a popular initiative by an ordinary Kenyan would be simply impossible?
No, we've had similar attempts before. One was by them, ODM. The other one was by my friend Dr. Kuro Okot, through Punguza Mizigo. And you saw how it was torpedoed, fundamentally by the state.
Paul, I need to take a break, but
yes,
I know you
I just want to say this. You know, the courts of law and judges are supposed to be led by evidence. And you cannot ignore evidence that is before you and create your own set of facts. And the evidence was very clear. The evidence was that the steering committee had died, did not exist at the time a popular initiative was started, did not exist at the time the popular initiative was being conducted. The evidence was that Dennis Wawero and Junet Mohammed are the ones who had gone to IEBC and told IEBC that they are starting a popular initiative. They got a go-ahead from IEBC. They collected signatures. They delivered the signatures to IEBC. They delivered the bill to IEBC. How can the judge create their own set of facts when those facts are actually facing them and insist, without any facts, that the president is the one who is conducting this? Then you cease to be a court of law when you are not guided by evidence.
Okay. Paul, on that note, I do want us to take a break, and I don't want our viewers to get too lost in the legal discussion that's happening here. So we're going to talk a bit of politics when we come back. But in addition, we have some tweets. This is some of the feedback that's coming in. Remember, 22422 is the SMS line, and the hashtag is Newsnight. We can look at the feedback on the other side of this break, but also we'll be showing you live images, both from Juja and Bonchari as well. We're actually seeing reports that some sort of chaos has erupted at the Juja Tallying Center as a group of rowdy observers protested stolen votes as the PEP's Koimburi takes the lead with vote counting halted. That's the latest update that we've received. We'll be showing you live pictures from there and also what's happening in Bonchari as well. You're watching Newsnight. Stay with us. So much more on the other side. Welcome back to the program. You are watching Newsnight. Before I get into politics with my guests, let me immediately take you to Juja in Kiambu County, show you images from a couple of minutes ago. We're going to put that up on the screen, where chaos erupted at that tallying center after rowdy observers protested quote-unquote stolen votes with the PEP, that's the Progressive Empowerment Party's candidate, George Ndongo Koimburi, taking the lead, still in the lead, dare I say, with vote counting halted. Let's listen in. Okay, we can see pictures there. That should be Moses Kuria, MP Gatundu South, who has, it is believed, a stake in that PEP party and the candidate leading. I think we also saw the Kiambu governor also there, quite unhappy over one issue. Hopefully we'll get our Stephen Leto a bit later on to tell us more. But the last numbers that we got at about an hour ago, okay, no, those should be rather outdated by now. We'll get the latest from Stephen Leto as soon as we can get him on. And in Bonchari as well, we are monitoring what's happening there. As of 15 minutes ago, out of 22 polling stations, Pavel Oimeke in the lead with 1,707 votes, followed by UDA's Teresa Oro, 1,415, and Opore of Jubilee with 1,261. Those were the results as of 15 minutes ago in Bonchari. But these are still pictures from Juja. This is what has been happening there over the last 20 minutes or so. And I believe even the vote counting has been halted so that sanity can reign and then the process can continue. But what we've been told by our team on the ground is that there was chaos as rowdy observers protested what they term as stolen votes, with the PEP's party candidate still in the lead. That's George Ndongo Koimbori, followed by Jubilee's Susan Waititu Jerry. And we'll give you more updates on this even as we carry on with the broadcast. All right, we'll show you more from that location a bit later on in the broadcast. My guest is still here with me in studio, and I want to talk briefly about the politics around that judgment. And we have some feedback actually, can we pick one or two of those right now? Okay, these are some of the views of Kenyans this evening. This is what you're saying on Twitter. Let's see who we have there. Erastus Korir says, I heard Paul Mwangi saying that at this rate it will be difficult to amend the Constitution. I think the framers of the Constitution intended it to protect Kenyans from a powerful executive, as in Kenya's history back in the 70s and 80s. That's Erastus Korir. All right, another tweet. This one from Fred Okango. You say the rule of law meant that law and justice are upheld by an independent judiciary. The judgments of a court of justice have to be respected by all, but can be challenged by the aggrieved. That doesn't mean that they're undermining them or the independence of the courts. It's just a search for justice. Maybe we take two more in the interest of time. Jacob Joseph Washira says the judgment bell was a resounding gong that the ringing can still be heard even after any other higher court decides what it will. And let's take one more maybe. Let me see. Jack Awele, you say there's a big distinction between the constitution making and constitutional amendments. Can the threshold used to make the 2010 constitution be used to stymie constitutional amendments? Okay, we'll take a few more a bit later on in the program. But President Harvey, let me start with you on this question. What do you think is the effect of this judgment on the 2022 elections? We had heard of political formations being formed around a successful BBI, how to share power, who runs for president, who runs for prime minister, deputy prime minister. All that was in the back of the minds of political players. In the possibility that there will be no BBI amendments between now and the next general election, what could happen on the political front, in your view?
What should and what ought to happen in August 2022 is for us to have an election in the manner in which we have designed to compartmentalize the offices through which our rulers or servants will serve Kenya. There is no anxiety, there is no hurry And if there is any anxiety, it prevails in the mind of very few individuals, because this initiative was not an initiative of the people. And I have said, and I think this line is overused, time without number, that the problem we have in our constitution is one of implementation and not one of reform. If you may ask yourself, Wahiga, and Paul Mwangi may also ask yourself, how much had been allocated for the BBI process? Tens of billions. Could that money have emanated from the shallow pocket of Junaid Mohammed or Dennis Waweru? How many people congregated at the Bomas? 6,000? Did these two have the wherewithal to make such an enterprise? How many went to Naivasha? 300? Who called the meeting at Sagana? Who gave MCA's grants? Was it Junaid Mohammed or Dennis Waweru? Look, the only weakness I suffer from is speaking the truth. And if it is the truth that I spoke before those judges that culminated in this judgment, then there is something wrong if we are questioning that truth.
Okay. Paul, let me ask you this, because this is a process that you are tasked with that originated from the handshake, and you are quite close to that. Some of the finer details around the handshake on the steps of Harambee House. If the outcome in terms of constitutional reforms cannot be achieved, at least going by that High Court ruling, what happens to the handshake? Is it expiry near?
No, one, I have no doubt from the history of the handshake that this handshake is holding on to the end of the president's regime.
When is the end?
To the end of the president's regime. I have no doubt that they're going to stick together, for one. But secondly, I think you've covered politics in Kenya for a very long time. And Kenyan politics is very dynamic. And I can promise you the next elections will have nothing to do with BBI. We will not be talking about those clauses by the time we go to people in Kenya recalibrate very fast. Formations will change very speedily. Concerns will change absolutely. By the time we get to talking about what people are voting for in August, I can tell you the conversation is going to be a totally different conversation. And that's why I think Honorable Raila says he puts BBI as one issue and the election to 2022 as another issue. And because he knows how dynamic Kenyan people are when it comes to politics, it changes very drastically. And it will change that drastically.
Gentlemen, I want to ask you both, and maybe we can put that picture up, some of the images that we are looking at from Juja. And I want to hear from you on what it will take to ensure that, whether it's a by-election or a general election, that scenes like these become issues of the past. And I know one of the promises that the BBI proponents were pushing was that if we pass the BBI, images like this, well, I mean, it's hard to promise, but will become an issue of the past. Nelson Harvey, does this concern you when you look at that in a by-election with an IBC that isn't fully constituted, depending on how you look at it, and in terms of solutions, whether through BBI or not through BBI, to ensure that this becomes an issue of the past?
Not so long ago, the Cabinet Secretary in charge of Interior and Coordination of National Government, Fred Matiang'i, said they will ensure that BBI passes and there will be peace before and after BBI. Now in the morning, a lady from Tarbo called me when I was in a radio talk show. Her name is Madam Rhoda. She said, what is happening in Bonchari? Is it a police recruitment exercise, citing from the large number of police officers, or is it a by-election? Look at the nonsense in Juja. This is what the proponents of BBI wanted to subject us through on account of a referendum. It was going to go through at gunpoint, as you can see, because they knew it was an idea that did not have any receptive census from the people. And I honestly believe what we need to have as a way forward is to guarantee electoral fairness and justice. What are the issues that were pointed out by the Supreme Court in September 2017? Transmission of results, network problem, Kim's kits inability to identify the voters, a server that is non-existent or always moving. You get it? Failure and or refusal to accept outcomes of the result. And we have a constitution that has set an elaborate framework for this. We have an IBC Act and an Elections Act that is quite elaborate. Where is the problem? The problem is this. There are individuals who want to sustain themselves in office or want to ascend into office, yet they know they do not have the support, the will of the people. This is what you're saying. Because you see, like in Juja, it is Moses Kuria's party that is popular. But they don't want it to win. They've brought in police. In Bonchari, it is ODM. But Matiang'i does not want the ODM candidate to win. He's brought in the police. It is a police state. We cannot have a police state
and those who
at this stage now.
The police are there to calm the tensions between different parties. Some would put it that way. But Paul, the BBI, some feel is weak on electoral justice, electoral reforms, and deals with what happens after the election, where you now allocate seats depending on what the BBI would have said. Why were those issues not sort of fully covered within the BBI? Did Kenyans not ask those questions to you when you went around the country?
We went through everything that has ever been done for electoral justice in Kenya. And you cannot fault the fact that there have not been enough laws. In fact, it's one of the places where a law is literally changed every time before the next election. Commissions are changed literally every time before the next election. So there's another problem apart from the law. There's another problem apart from the fact that we have new commissioners. And that is the problem we were trying to get to. And so we can't keep talking about how we are going to change laws. We've been doing that since 2007. It doesn't seem to have changed much. So we really need to address what is it about elections. What do they usher in that is making people fight? And that is what we tried to deal with. But you must also remember Kenyans love. Kenya is a very, very political country. Highly, highly political. And everything in Kenya is political. So there will always be, we will never have the kind of elections people think that we are going to have, where people just go quietly and vote and there's no noise, there's no volume. And I don't think that's not Kenya. Kenya is a very, very highly political country. The question is whether we can make people understand that and realize they don't have to fight about it. They will still make noise, that they will. And I don't think, and that's the people, that's who they are. Whether they'll fight or not is what we must deal with. Whether they are able to get through an election is what we must deal with. And if they can have this healthy political competition without it ever having to resort to animosity, that anybody can live with.
Paul, what you're basically saying, and maybe you should be facing the man next to you even as you say that, because he recently announced that he will be vying in 2022 somewhere in Nairobi County. Are you telling him that we have too many laws that have still not provided a solution to deal with electoral injustice, and that the laws might not help him on the day of the election? Is that what you tell him this evening? I'm
actually very happy that he's going into politics, because he will see it's a totally different ballgame from. And I wish him well, for real. But he will realize a totally different ballgame than what he has been doing. But I will tell him not to be discouraged because of the noise he's going to meet on the ground. And that those are Kenyans, and that's how they are. And don't always interpret that they're about to fight or they hate each other. And don't sponsor divisions. Celebrate the competition, but I will ask him, don't sponsor the divisions. Don't make it impossible for people to live together after they've competed. But for all intents and purposes, enjoy the competition.
Okay. Gentlemen, I want us to wrap up by talking about what next. In your view, with where we are now, if both of you had crystal balls, some say we have an election coming up on the 9th of August, about a year and 2 months or so from now. Can we really go through an appellate process, Supreme Court, maybe pass BBI for those who are optimistic about that, have a referendum, new constituencies, and an election? President, I'll start with you on that one.
Well, in my 18 years in practice, I've often had to withdraw appeals that are filed in the heat of the moment. I think as they sleep on the cow's hide, as we say in Kalenjin, for the next few days, they realize the futility of this appeal. I'm not here to project doom on that appeal, but I think perhaps if they were to sit down and look at this matter a little bit more carefully, they realize that what the High Court did was the correct thing. And it is least likely that the Court of Appeal will overturn this decision, unless, of course, the Court of Appeal is captured, wants to be dishonest. But in my humble view, this is an issue that should be a beacon of guidance to the political class, not to tinker with the structure that is the Constitution. Let President Uhuru Kenyatta finish his term. The 4 agenda is very fundamental. He should concentrate on it. Let him not be beguiled by this interruption into his term by Raila Odinga. Raila Odinga can wait to run in 2020. But these upheavals that he's subjecting Kenyans to is not necessary. And I say this with profound respect because, as you're very well aware, I was on their side in August 2017. We agreed we'll go to our polling station, vote, and come with the forms. I went to Nangili, voted, came with my forms, and at 7:30 p.m. I was at KTN. I was the only one who brought those forms. These people never intend to win an election. So why are they subjecting us to this expensive enterprise? If you want to win an election, you must prepare to win an election. But it's quite evident they just want power sharing and no commitment towards winning an election.
Which people are these you're referring to?
These ODM friends, former friends of mine.
Former friends?
Yes.
Okay. Paul, as you wrap this up, way forward even as you respond to that.
You know, in my language they say, do not hide in the open field wearing a white cloth. Ever since this judgment was given, you're getting a lot of free advice by people. This thing is, don't appeal, this thing will never succeed. The president is getting a lot of gratuitous advice and being told, no, you can finish your term nicely. Of course.
What sort of advice is Raila Odinga getting?
The same. All of us, there's a lot of free and gratuitous advice. But the purpose of all that advice is to try to demoralize the BBI trade. And I can promise you it's not going to be demoralized. I can promise you, so long as if it were to my advice, and I believe it, unless that something changes and get different instructions, this is going to the wire, to the last court. So we are not going to say that 5 judges of the High Court have spoken and you accept that. It's too grave. The things that have been decided are too fundamental not to be challenged all the way to the last court in this land. And if you tell me, if you ask me, that's where this will go. If they want to give it up somewhere along, that is up to them. But from where I stand, the fight continues to the end until we establish that the High Court was wrong and that is bad law.
Gentlemen, I'll take those as your final words. Thank you so much for joining me for this discussion. We've had here with us Paul Mwangi, former BBI Joint Secretary, and Nelson Harvey, the President of the Law Society of Kenya, both of them with different views on the way forward. But that's the reason why we have a show like this, to allow those different opinions to come through. And gentlemen, I will thank you so much for your time this evening. Now, I want to take you to Rore Ward in Nyandarua and show you final results from that by-election in that ward. Remember, this was hotly contested. There was UDA, Jubilee, a kind of contest there. And of course, the Kieleweke Tangatanga division showed Francis Muraya Githaiga of UDA. They are 57% of the votes, 4,303. This is all polling stations, 26 out of 26. While Peter Dhinji Kiriga, 3,143 votes, 42% of the votes. And then Isaac Nderi Ndegwa there with 51 votes. So clearly it was a 2-horse race, but that is how it is at the moment. UDA party taking the win there. And I actually think we've seen a tweet there from Deputy President William Ruto. We'll try and put that up for you as soon as we can, even as we continue following what's happening in Bonchari, where we will need to update you on the latest results. And also in Juja, where we've seen pictures of the chaos that rocked that national, sort of the constituency main tallying center within the last 30 minutes or so, as some protested what they're calling stolen votes, some election observers. But this is Rore, and this is what we are showing you at this moment. And those are some live images. We expect the announcement to happen any minute now, and we want to bring you those images live here on Citizen TV. Let's listen in. All right, as we mentioned earlier, we have been waiting for the final declaration of those results. Oh, I think that's about to happen now. Okay, but first, let's look at this tweet posted by Deputy President William Ruto at, let me see what time this was, about 50 minutes ago or so. He says, "We thank God for Hustler Nation victory in Juja and Rore and the awesome show in Bonchari. A big congratulations to all our Hustler teams for a sterling performance against all odds. Hongera to our competitors. Let's keep it issue-based and pull together. Sasa tupange uchumi pamoja na Big Four." All right, we're going to have to wrap up the show here. Final results that we have from Bonchari. These came in about 10 minutes ago or so. 26 polling stations. ODM's Pavel Oimeke, 1,880 votes. Oro Teresa of UDA, 1,790 votes. While Opore Jubilee, 1,556 votes. That was as of 11:07 p.m. And of course, I've shown you some of those results from Rore, where all the 26 polling station results have been confirmed. And what we're expecting is a declaration at that location where we had brought you pictures a couple of minutes ago. Of course, what we're not able to show right now, we'll have comprehensive coverage of in our bulletins, starting with daybreak tomorrow morning from 6 a.m. And we'll keep showing you updates even on our social media platforms as well. So please keep it Citizen TV, both on our TV channel and of course on our social media platforms as well. But we need to wrap it up. Many thanks for tuning in. On behalf of everyone who's made this broadcast possible, thanks so much for keeping it Newsnight this Tuesday. Our sign language interpreter tonight has been Yulan Zale. My name is Wahiga Mwaura. Stay safe, have a good night, and we'll see you soon.